Shall we start, sir? Okay. Good evening, everyone. A very warm welcome to our esteemed dignitary, Ms. Akash Gupta, sir, and all the participants to the 7 days online National Capacity Building Program on Mooting Skills and English Language. Where today's session is all about strategies, skills, and attributes required to excel in mooting. I am Saurabh, the moderator of today's session. Thank you for joining us this evening. Now, before I move forward, I would like to mention that the last few minutes of the session will be reserved for question and answers. Today, we are honored to have Mr. Akash Gupta, sir. Sir is an assistant professor at Jindal Global Law School, where he specializes in teaching arbitration courses. Additionally, he is a visiting faculty at the National Law School of India, Bangalore, where he teaches his elective courses, advanced courses in arbitration. Setting aside an enforcement of arbitral awards, he is pursuing a PhD in arbitration from GD Goenka University, Gurugram, and sir has completed his LLM in International Commercial Arbitration Law from Stockholm University, Sweden. Sir graduated with a BA LLB honors degree from Tamil Nadu National Law University, Trichy. Additionally, Sir has attended prestigious summer and winter schools at the Paris Arbitration Academy and Hague Academy of International Law, both of full scholarship. Since joining Jindal, sir, in 2019, Akash sir has not only taught arbitration courses but also held several editorial and advisory positions. He is the assistant editor for the Indian Review of International Arbitration (MNLU), a peer review board member of the Indian Arbitration Law Review (NLIU), and an advisory board member of RMNLU Law Review. Akash sir is a prolific author with 13 publications, including 4 Scopus publications. His research covers a broad spectrum of topics, including sports arbitration, electronic evidence, corporate social responsibility, fertility fraud, consumer ADR, ethical aspects of AI in healthcare. His work has been published by prominent publishers such as Sage, Springer, Thomas Reuters, Road Lodge, Nova Science Publishers. In addition to his academic and professional achievement, Sir has actively volunteered for an arbitration and judge in over 100 moot court competitions, including prestigious ones like BIS, Jessup, FDI, and Stetson. Not only Sir is an immaculate professor, but Sir never misses an opportunity to interact with young budding lawyers like us and provide his valuable insight. Therefore, I am very honored to invite Sir to us with this session. Over to you, Sir.
Thank you very much, Saurabh, for the introduction. It's always a pleasure to collaborate with Professor Kalpesh, and thank you so much, sir, for
It's our
inviting
honor,
me
sir.
and giving me this opportunity to interact with law students, to interact with experts. And I must congratulate Professor Kalpesh for doing this great work where he's trying to, create this group of people where we can bridge this gap in between the professionals, the students, different stakeholders. So we should all appreciate Professor Kalpesh and we should give the full support. Thank you so much, sir, for this. Okay, so Professor Kalpesh has asked me to cover certain topics with respect to Moot. So this hold a 7 days online national capacity building program on mooting skills in English language. So I think it's a great initiative, one of its own kind initiative, which he has thought of. I'm not sure if there is something of this nature happening in India. So first is that there are some law schools, especially in the West, which conduct some things like Wismut School, especially the German law schools do this. So this is one of its own kind. And Professor Kalpesh and his team have to be credited for this. Thank you so much for doing this and giving us also the floor to share our experiences. So for me, the topics given to me is strategies, skills, and attributes. So there are certain pointers which has been given already in the registration link, the brochure, and also it has been shared with us. So I'll start instead of giving more like a presentation. What I want to do is I'll try to align this with some of the pointers which is pretty much used in all of our modes. Doesn't matter whether it's national mode, state modes, or it's the international modes. So one of the things which is written in the first part is use of case law in moot court argument. So some days back, somebody texted me, one of the law students, that how do we use case law? And then it came to my end that this is something which I have to share in this class. So how do we use case law? So there are different perspectives to this. One perspective is that, when you go to a moot court and you start arguing, let's say you are arguing issue 1, every time what you say, what you argue, you say that this has been elaborated or this is something which is decided in this case. So for every sentence, you start using a case law. Now, this is something some of us do this in the Moot Court memo, the memorandum, memorial, whatever name you call it, or some of us start doing this in the oral rounds also. Now, this is one perspective where you use a lot of cases. Are you able to hear me? Is it audible?
Yes, audible, audible.
Okay. So there are two perspectives to this. One is this, that you use a lot of cases. Now, this is something which I call case dropping, right? Like you have bomb dropping, that you call it case dropping. So you say something, then you use a case, then you say something, then you use a case. It's very difficult, especially in the oral rounds, to follow this. Now, this is one perspective. Let's talk about the other perspective. The other perspective is that you make a full argument on a specific point of law. Once you have done that, to substantiate that, you use a case law which is pretty much connected to that particular subject matter. One case or at max two cases. Now, there are two views, there are two perspectives to the same. How do you use case law? Now, which one is better and which one we should do it? So everyone has a different perspective. Maybe what perspective I share, maybe that is something which is the majority view, which I think, but there may be some other judges. So please understand this. In a moot court competition, it's a bit subjective. Please don't think that there is an answer key like the MCQ answer keys and it's going to be one answer. But I have just almost more than 100 competitions so far, and I did quite a lot of moots, more than 10 moots in my law school. Then I did also another West moot from my Stockholm University when I was doing my LLM. So I'm just sharing my views. So in India, we end up doing a lot of case dropping, especially when you go for these international moots. And then you start saying in 5 sentences, you use 5 case laws. Put yourself in the shoes of the judges. Do you actually think it's very easy to follow? So you have to think, you have to preempt, you have to understand things, putting yourself in the shoes of the judges. If you think that that is something which is very easily understandable, then it's a very good way, right? But it becomes very difficult. So the international standard, also the good national moots in India, if you start dropping a lot of cases, it's not something which is highly encourageable. For example, a lot of Indian students have this misnomer that the more cases you use, the more points you get. So what you end up doing is you start using cases for, let's say, the definition of arbitration agreement, right? When you use, definition cases for definition of arbitration agreement, it doesn't mean anything, isn't it? So you have to use cases when it is required. So to sum up this whole discussion on use of case law, you should use it when it is required. You shouldn't overdo things. And you should actually use it when it is connected and it is helping you to make a point. So let's say if you have two issues to argue in a moot, in one issue you have 2 or 3 cases. That's going to be more than enough. Instead of every sentence you say, and then you say that this case has been cited on page number 35 of my memo. Because understand the, okay, are you able to hear?
I think it's audible. Yes.
Is it
What
better
about other
now?
participant? Yeah, yeah, I think yes, everything is fine.
Yeah.
It's fine.
Sir,
Everything
you're,
is fine. I don't know.
yes, sir, you're completely audible.
Okay. So just to sum up with this part of use of case law in moot court. So this is the ideal way, but I'm sure that some of the judges, especially with respect to, guys, you have to decide. Is it okay? Just a second. Let me tell me if it is better.
Can you hear me now in a better way, or is it the same?
No, it's
It's
better.
better. Better, sir.
It's better? Okay. I think there is some issue with this. Okay, this is better, right? Perfect. Okay. So just to sum up this whole case law discussion. The middle way is this, that for everything which you have to focus and prove a point, you use a case law. Okay. But don't overdo things, and in that you lose out the credibility. Now, why do I say that you shouldn't do a lot of case dropping? Because it eats up your time. Understand this. Whenever you drop a case, you throw a question that you want to ask a question on this. So you have to save time. You don't have to give room to ask questions. The moment you quote, let's say, 5 cases in 5 minutes, if I'm your judge, if I'm your arbitrator, I may have a question on that. So it's very good, it's very smart of you to use cases when it is required. Now, this is something which is specifically for oral rounds as well as for your memories. So whenever it is required, whenever it helps you to prove a point, you should do it. But don't do things where it's not required. Okay, so this is with respect to how you use case laws effectively. Any questions or any specific scenarios that you have came across with respect to use of case laws and you want to put this across now? So if you have to do this, please use the chat box. Meanwhile, I go to the next part. If you had any experience and you were confused, how do we do that? So you can put this on the chat box and I'll come back to this. Okay. So please feel free to write your questions on the chat box. So this is one major issue, case laws. And the other part of the case law is, if you keep on saying that this is there on page 34 of my memorial, the judges have to flip pages and go there. Okay. Every time if you do that, you lose the credibility. Okay. So please don't overdo things with case laws. But let's say if there is a landmark case law which you have to make sure that the judges read, then in that case you have to say, members of the tribunal, I would like to draw the attention towards page 39 of blah blah blah, which is a case law on this, and then you read it out. And let's say if it is very important, then you read it out like, here comes the important part, which is blah blah blah. So this is how you actually get the confidence of the arbitrators or the judges. Okay. So these are my 2 cents on how do you use case laws in moot courts. Okay. If you have a question, please feel free to write on the chat box. Then team coordination and team management. I think when Professor Kalpesh has been drafting this whole brochure, he has got very good keywords. So the easiest way to excel in moot courts, I'll say that you go to his brochure and you look at the keywords. If you follow the keywords, you'll get what things you have to focus on. For example, he has written team coordination and time management. Now let's spend some time on what do we mean by team coordination. Team coordination is one, the speakers coordination. So usually in the Indian moots or foreign moots also, you have 2 speakers in general, right? So 2 people who are sitting on the table, one person has to go to the dais, speak, then come back. Sometimes in arbitration moots, it's 2 people who sit on in a setup where you have a table and all of this, and then you have other teammates right behind you. So in larger sense, team coordination is in between the 2 speakers. So for example, if let's say that, you are one of the speaker, you are speaking and your teammate is sitting, let's say both of you are sitting on the table, it's more like an arbitration moot. Let's take an example of Jindal West pre-moot. So Jindal conducts West pre-moot, which is more like a practice round moot for the West Vienna and Hong Kong, which happens in Jindal campus itself, where the setup is like this, that you sit, you have a table next to you, you have to argue while sitting. So what do you mean by team coordination here? One is that when I argue, the other person has to help me out when I say that, members of the tribunal, I would like to draw the attention towards page 39 of the record. So instead of me going to that page and flipping it, it should be my co-speaker who does it. Okay. And the co-speaker does this. For example, when the co-speaker flips pages, the co-speaker actually points this, that this is the line, all of this. When you do this, it looks as if you are a good team. Because when I'm speaking, I have 10 minutes or 12 minutes or 15 minutes at max. Even in which this is the time limit. So when I say that I have to draw the attention on page 34, my co-speaker does this. This is how you showcase that you are a team. Okay, that's one. Second, the co-speaker helps you with the timing. So let's say if I am going to complete my time, the co-speaker writes on the chat that question mark or let's say time, and you just paste it. Another example is, let's say that somebody asks me a very tough question and I'm not able to answer that question. I spent 30 seconds, then I spent 1 minute, then I'm stuck with that question for let's say 3 minutes. My co-speaker has to write on a chat a keyword which we used to use, saying that you have to move on. That's how you showcase that we are coordinating as a team. Because let's say if I'm on my own, okay, and I'm stuck at some point of time and my co-speaker does not help me with that, how do you actually showcase that you are having a good teamwork? Teamwork is not only helping the other speaker when somebody doesn't know the answer. In Indian jurisdiction, when we talk about teamwork, a lot of us think that majority of it is when I'm stuck with a question, you answer it on a chat. But that's not the reality. The reality is how you coordinate as a team, how you behave as a team, whether you have a good coordination, whether somebody helps you when you are stuck, they let you know that your time is running out. Why don't you ask for a time limit? But please understand this, when you do this team work, it doesn't mean that you start talking to each other during the rounds. You have to use the chits, you have to write it, and then you can paste it. And sometimes some of us overdo this also, because let's say somebody asks a very tough question and we think that our co-speaker doesn't know the answer. So what we end up into doing is sending a lot of chits. Now understand this, when you send a lot of chits, a lot of answers to your co-speakers, at some point of time it becomes demeaning also, because then the judges think that, oh my god, this speaker doesn't know anything. So you have to be very cautious with this. Okay, so before we go to the next part of time management, any questions so far? Because the idea of this is, if you have questions or if you have any scenarios or any experience which you had faced, and then you let me know that, and then I help you out that how we actually resolve that particular issue. So if you guys have any questions with respect to these things or any other experience in the moods, please feel free to ask now. Any questions so far? Okay, so I don't see a question. So let's go to the next one. The next one is time management. Let's say that you have 15 minutes to argue, okay? And you think at the end of the pleadings that in 15 minutes you are not able to finish your pleadings. So you have to ask for an extension. So what should be the extension you should be asking? Why don't you use the chat box and write 30 seconds, 1 minute, 90 seconds, 2 minutes, or more than 2 minutes? What time extension that you will be asking? Anyone? You can just write on the chat box. The scenario is very simple, that you are running out of time and you have to argue some more issues, some more pointers, and you have to ask for an extension. What should be the ideal extension you should be asking for? So we have some answers right here on the chat box. Gyan, 30 seconds. Harshita, 5 minutes if the argument is still left. Satish, 2 minutes. Ayushi, 30 seconds. AK Pandey, 2 minutes. Vishwani, 90, 30. Minimum possible 2 minutes, 2 minutes, 90 seconds, 30 seconds. Okay. Now understand this. There is no written rule on any of the competitions that what is the extension that you can ask for. So who decides this? It's the discretion of the judges who's actually judging your round. Okay. Understand this. There is no written rule, but there is an unwritten rule on this. Let's say there is a team opposing to you. Okay, that team finishes their argument in exact 15 minutes. Now you want an extension to cover your arguments. Is it a good thing to ask for extension? That's first. Okay, that you have to ask for extension. Now, before getting into this question of how much time you should ask for extension, let's understand why do we need extension. Let's go to the root cause of the problem itself. If you look at this problem, majority of us have this problem because we never preempt and prepare accordingly. For example, when I was doing the Moot from Stockholm University, where we got into top 16 out of 372 teams, one of the things which our Professor Patricia Shaughnessy and Professor Fabricio, they taught us this, that whenever you have to argue, you have to prepare 3 set of pleadings. And when they said 3 set of pleadings, they meant this. They gave us this example that let's say if you get a judge who is asking a lot of questions, you get a judge who is not even asking any questions. Then there is a judge in the middle who asks some questions but not a lot. Can you have the same pleading for all 3 of them? So they gave us this very relatable example that let's say if you have to drive on an expressway where the speed limit is 120, do you put your car on first gear or second gear? Not really, right? But let's say if you are roaming around Connaught Place in Delhi, can you put your car on the 6th gear? No, right? So what you have to do, you have to prepare 3 set of pleadings. One, let's take an example of 15 minutes total time. One is more like 5-7 minutes. 2 is like 9-11 minutes, or 8-10 minutes. The third one is 12-13 minutes. If you have prepared these 3 pleadings in advance, let's say you get a judge who starts asking you a question in your introduction. So you switch your gear. You understand that this whole argument, I have to shift to the gear where I have 5 minutes of arguments. That's it. So 5 minutes, it's your argument. Plus they'll be asking questions because they're asking a lot of questions. So the root cause of this problem is this. If I ask you, people who have replied, why don't you reply now on the chat box? How many of you had 3 set of pleadings and you practice this before going to these moot court competitions? How many of you have done that before this? Having 3 set of pleadings. I get 1 yes, Harshita. So do you realize this? That if somebody is asking a lot of questions and you have prepared for like, let's say 13-14 minutes for a 15 minutes pleading, it's not going to work out. So the root cause of the problem is this, okay? So all of us have to first understand this, that we need to have separate style and separate pleadings for separate set of judges, okay? And then you have to read your judges by the time you enter the room. In the first minute or so, you have to read the judges and you have to shift the gear. Now, this is the problem with why we fail to manage time. Now, let's come back to the question. Let's say that at some point of time, you are of the opinion that you are running out of time. So what you should do? The ideal thing is, before running out of time, let's say if I have 15 minutes of time to argue, 14 minutes, 20 seconds is the last cutoff time where you have to request for an extension. When I say request for extension, before 14:20, you have to request for it. That members of the tribunal, I see my time is running out. I request for an extension of this much time. Now, how much it should be? Ideally, some of you have already given it on the chat box, the right answer. It has to be the bare minimum. So the minimum which you can ask is 30 seconds, at max 1 minute. Understand this, the rule book provides for a time limit. The extension is more like a discretionary thing, which is not a right for you. Any of the judges can say no. So the minimum it is, the better it is. Okay. So 30 seconds at max 1 minute, but I have judged moots where the students also ask for 3 minutes of extension, 4 minutes of extension. Understand this, the moment I give somebody 2 minutes of extension, what if I don't give the same time to the other team? Do you think I'm being fair to both the teams? Or do you think it's subjective? So, but I'm not saying that none of the Indian judges will give you more time. I'm saying some of them gives it, but let's respect time and you get points for this. This is more professional, isn't it? That you finish on time. If you don't finish on time, you ask for an extension and you ask for like 30 seconds, 1 minute, and then you wrap up. But here comes the important part, guys. How many of you have faced this that a lot of times in the moods you experience this that somebody runs over time? Let's say after 15 minutes, they request for an extension when the judges stop you. After that, you seek an extension for 1 minute. After 1 minute, you again start arguing. You must have seen this if you are already here. That is a big no. Understand this, when you are over time, you never argue. You just wrap up the whole submission. When I say wrapping up, it means that you can't say that members of the tribunal, now I would like to draw the attention towards page 34 of the record. You are already over time. Then you want me to go back to the record, flip pages. It doesn't add up anything, right? Because you asked an extension to wrap up the arguments. You never asked an extension for the whole argument. And in a moot court, it's not like a full day hearing, right? It's not like a live case where you get, it's an ICJ hearing where you get 2 hours of submission, right? So please understand this, okay? So never ask for an extension, take time, then you go over time, then people are trying to stop you, then you again overstep time. Understand this. You get points, okay, from the judges. If let's say the judges are of the opinion that you are not following time, doesn't matter how good you are, but the points will be affected. Second thing which you should keep in mind, you should write this down. If you are looking for, getting something out of this session, it's not about how much you argue, how many pointers you cover in your presentation. You get points even if you speak for 2 points per issue. But if that is convincing, you get 90s. Okay. Please don't think the more you speak, the more cases you refer, the more principles you refer, the more time you take, you get more points. If you are very crisp, one issue, you have 2 cases, 2 pointers, and it's very precise, it's very clear, it's easy to understand. You make more points than somebody who is overstepping time, somebody who is using 20 cases in a presentation of 15 minutes. Please don't think more arguments, more cases, more lengthy, more complicated English language, the more points you get. It's a misnomer. If you don't trust me with this, why don't you go to YouTube and watch the finals of Jessup, Wiss, Stetson, FDI? You'll find one thing in common. People put one piece of A4 size paper in their front. They put a bundle which has all the problem pages. That's it. While in India, what you see, people have so many notes, people have scripts. Some of the teams follow this, that you have a full script, which starts from this: good morning, members of the tribunal. My name is Akash Gupta. To my left, it's Rupal Mishra. You get this? So please never prepare scripts, because it's not like you are acting in a film. It doesn't have to look that scripted. And sometimes when somebody asks you a question, the problem with the scripts is, let's say you forget something, you start thinking about that script, even if you know the answer. So it's better to have pointers on an A4 piece of paper and you just keep it right there on the table apart from the problem. So this is my 2 cents on time management. It's always better to follow time, to respect time. And even if, let's say, you think that you have to argue, let's say 4 pointers, but you could only argue 2 or 3. If your time is out, but you did very good with the 2 pointers or the 3 pointers, it's fine. Not every time you'll get the chance to speak whatever things you wanted to, but never push it with the judges that no, I'm still left with one of the issue. Why don't you give me another minute? Okay, because they don't know how many pointers you have. Sometimes you think that this is super important, the 4th point, but they are already convinced. But what happened that you start having an argument with the arbitrators or the judges that I have to speak I have to present the 4th issue also. Then you start losing points. So it's fine. Sometimes things go south. Okay, but let's be patient and let's move to the other parts. So please don't do that. Okay, that's about the time management. Okay, so we have a question from Rupal. It's the capacity of a speaker to complete the arguments within time. It is certainly difficult to complete the arguments even after getting an extension. True, I agree. So this is why I say that you need to have a very shorter pleading, mid-range pleading, and the longer pleading. When I say shorter pleading, I'll say that for 15 minutes, I'll prepare my speech something like 4 minutes. So even if somebody asks me a lot of questions, I'll be able to cover whatever things I want to, because 4 minutes is very less. So even if you ask me a lot of questions, I'll use 4 minutes. And it's a trick how you actually come back to your own roadmap. So let's say every time somebody asks me a question, what I say after answering it, I connect it to some of my related points and I say, I answered the question, and then I say that leads me to my next point, which is my roadmap, which I wanted to argue. So the transitions play a very important role. If you don't know this trick of how you actually go back to your own roadmap, if you don't use transition, you will be entering a rabbit hole and there is no way out that you can get out of it, because then it's the judges who is deciding which pointers you should argue, right? So of course it depends on the capacity of these speakers and you have to be very smart. So this is why you should have practice rounds, this is why you should have pre-moots, or let's say some senior who gives you feedback for that, and this is how you prepare. Okay, it's not about how good you are or how bad you are. At some point of time in moots, it's more about how trained you are, because let's say this session, if you watch this session or the other sessions by the experts, you get a lot of insights which will be helpful. But let's say if you are unaware, nobody told you this and you never came across this, nobody gives you feedback, then let's say you go to competitions, you don't get a feedback, you come back with some low marks, you never realize what's your mistake at the end of the day. So I think it's better to get feedback and try to make a note of what are the things we have to work upon, and then you start acting on it. Okay, so there is another question, Vishwani, but in real life situation, is there a time limit in a high court or Supreme Court? You're asking me that whether there is a time limit in the high courts or Supreme Court. Okay, technically yes, but what's the time limit? It's very subjective. For example, for the admission stage, it's a different time limit. For the full hearings, for the full pleadings, there is a different time limits. The high courts work on a different time scale. In the Supreme Court also, and it also depends on several different dynamics. So that is something which is way different. But of course, there is a time limit attached to it, because otherwise you have so many cases lined up. So of course you have to wrap your arguments. But it's not a written rule that everyone will get this timing. But at least in moot courts, you have a fixed time limit, which everyone of us are aware of. Okay, so this is about team coordination and time management. Any other questions or any scenario which you have came across and you were not sure whether you did it right or wrong, or you never had a chance to ask somebody? So why don't you ask it now? Any questions?
Sir,
Okay,
I would like to ask one question.
yes. What's your name?
Saurabh, sir.
Hmm.
Sir, from your personal experience, can you share us what all are the mistakes a first time student, a first year law student is more likely to make on his first move experience?
Hmm. So your question is, first years make a lot of mistakes because this is
Yes,
the first thing they're doing. So what's your question?
yes. Sir, as in I guess 20 days, I have my first mood board. I
Hmm.
am prepared, but I don't know what all mistakes I'll be making. There are some kind of mistakes that are very common from first year law students, as
Hmm.
they don't know how to present themselves or what all points they should be taking from the case.
Hmm. Okay. So first things first. I appreciate law students who are in first year who start trying to moot. Okay, very good idea. I did my first moot in the first semester. So please don't feel sad if you don't go to the knockouts or how you perform, because you have already taken one step forward to try this. So I appreciate that. Okay. Second, how you actually learn it. On internet, you will find so many things. At least the easiest thing which you can do to learn oral advocacy, it's very simple that you go to YouTube and you start watching the finals of any moot. Because those finalist speakers will of course have learned something, have done something so that they reach the finals. So oral advocacy is something which can be learned through that. But this is the problem. You watch it, it's not that easy to learn it. First is watching it, then you have to practice it. The problem is a lot of people watch it, but not a lot of people make note of it. Like, for example, transitions, for example, time management, for example, how the speaker refers to the document. I'll give you an example, a very small thing. I'm sure some of you will be thinking that this guy is very picky with moods and stuff, but I'll give you an example for this. Let's say that your Saurabh is speaking in a moot court competition, and he say this to the arbitrators, members of the tribunal. I'd like to draw the attention towards page 39. Okay, page 39, which reads blah blah blah. This is scenario one. Second scenario is Saurabh says, members of the tribunal, I'd like to draw the attention of the tribunal towards page 39. By the time the arbitrators flip the pages, Saurabh says, which is an email from the claimant to the respondent. By that time, the arbitrators reach page 39. Then Saurabh says, para 2, line number 1, reads as blah, blah, blah. Then Saurabh says that here comes the important part, members of the tribunal, in which the claimant has said this. Do you see the voice modulation? When I said here comes the important part, in the first scenario, I said refer to page this, but I never waited for the arbitrators to move to that page. But in the second scenario, when I say move to this page, I request move to this page, then I explain what is there in the page. By the time you flip, when you open that page, I'm saying it's para number 2. You are trying to, you are trying to help the arbitrators or the judges to actually walk with you. It's not that you are instructing and then leaving them. Do you understand this? It's a very small thing. But trust me with this. When you start doing this in the moods, you'll see the difference in your points. It's just that a first year, I never say that first years are not capable enough to beat somebody who's in fifth year of law school. It's not about the capability. It's not about how good you know the law and all of this. It's all about, at some point of time, especially in the knockouts, it becomes more about the trainings. For example, Saurabh knows this, right? Because he's there in the session. And fortunately or unfortunately, he has to open his video camera for the whole of the session. So he has to listen. So he knows this. So maybe he'll do this in the next meet. But somebody who is not a part of this discussion, and let's say that person doesn't come from a law school where you have a lot of trainings on this. It's not about whether Saurabh is good at it or that law student is bad at it. Because Saurabh knows it, he's doing it, right? This is what I mean by training. This is the reason why I said that Professor Kalpesh has a very good idea of doing this. Like people like me or the other experts are coming in, having their experience. So this is just one example, Saurabh, which you can learn from internet. I'm not sure if this was there in my time. Because in my time, hardly people used to use LinkedIn. But now I see almost everyone is using LinkedIn, right? So all I'm saying is for a first year, there are some very good internet resources. For example, YouTube finals. On Loctopus or the Jessup website or the WIS website, you will get the best memos which are uploaded there. So you get to learn the memorial art from these websites. Loctopus has a repository, I guess. It was there in our time. I'm sure it must be there now. Moot, the best memos are already there. Jessup, the best memos are already there. All I say is this, the resources are already there. It's all about whether you are reaching to that platform or not. So that is one part. But of course, once you get to that resources, you start making notes, then you have to start practicing. When I say practicing, it's fairly simple. Let's say we are doing this here. Saurabh presents his arguments. Let's say he's going for XYZ moot court, and he does this with me. I take his rounds for 15 minutes, 20 minutes, and I give him feedback. This is what I mean by practice. You can do this horizontally, which means your peer group, your senior in the law school, or let's say your junior who is very good into the moot court. Or the vertical is you ask your faculty friend, or let's say where you interned, or somebody who's actually very good into moot court competitions. Okay, but this is the missing part. Just watching it, it's not going to help. And whenever you do these practice rounds, other thing which you can do, you can record yourself, when you do this practice with your friends or like peer group, and then you look at your facial expression. Sometimes when we answer questions, it looks that we have given very good answers, but you make faces. For example, if somebody says that I have two questions to ask, some of these speakers are like, but you don't realize that you are making facial expressions which are very reactive. So how you actually come over this is record yourself, and then you see how you react to it. Another thing which is something very helpful for anyone who's interested in mood or any public speaking. A lot of us have this problem. So you must relate to this, that some of us have an habit of saying something like this: hello, members of the tribunal, my name is Akash Gupta, and I teach at Jindal. You get the sound in the middle. A lot of us have this. So how do you overcome this? It's not a bad thing. Nobody is going to mark you down, but it's just how attractive your presentation can be if you remove this part. So it's very simple. You have to record yourself. Whenever you think that there is a gap, you have to take a pause. So for example, instead of that sound, what you do is this: members of the tribunal, my name is Akash Gupta. To my right is Mr. Saurabh. So instead of the sound, you take a pause. Very simple. And it's all about practice. Please don't think that somebody who does not have this issue, they are blessed with this. Not really. You have to just practice it. Did I answer your question, Saurabh? Or did I confuse you more?
Yes. Thank you so much, sir. Sir, somebody has asked a question. If opponent lawyer is giving false claim, can we stop them and provide our reference to claim it's a wrong claim?
Okay, so here's the thing. If somebody is saying something wrong in their set of pleadings, you shouldn't interrupt them right there. What you can do, you can come back in the rebuttal with that. That's what we mean by a rebuttal. Rebuttal is more like, let's say somebody has made a claim or somebody has said something which is not correct. So that is why you have a rebuttal. Instead of interrupting there or stopping them there, what you have to do, you have to make a note of it. Whenever you get a chance for the rebuttal, you just say that part in the rebuttal. Now, coming to rebuttal, please understand this. A rebuttal is more like a cobra attack. It's not back and forth. A lot of us start arguing the same thing which we have already argued in the arguments. A rebuttal has to be maximum, you have to reserve 1 minute. 40 seconds, you have to finish. I know some of the Indian moods, you'll have a rule that you have to reserve 2 minutes, 5 minutes. That's exceptional. In all the international moods, 1 minute, but people use just 30 seconds or 40 seconds. Okay. So please use rebuttals for making a very short statement, which can be wrapped up in 30 to 40 seconds, not more than that. And understand this. And please write this down. If you have to write the key things from this discussion, if you have to explain your rebuttal, I'm really sorry. That's not a rebuttal, that's an argument. There is a reason why you get time for argument, why you get time for rebuttal. If you have to explain your rebuttal, it's not a rebuttal, it's an argument. Okay. So every time when you make a rebuttal, you have to understand this. That is the reason why it has to be very short and crisp. It should be more like a statement. Okay. For example, I'll give you an example for this. For example, contrary to the respondent's argument, the respondent has failed to discharge the burden of proof with respect to the subject matter. Thank you very much, arbitrators. Done. This is my rebuttal. If they have failed to discharge the burden of proof, which is required from their side, it's upon them to reply now. Okay, this is how you do the rebuttal. Instead of explaining everything, and then some people also say, why don't you go to page 38 of the record? And then you start reading it. It takes a lot of time. Okay. The next question is from Ayushi. How a speaker will coordinate with his co-counsel. For example, he wants the researcher to pass compendium to the bench. Will he pass a slip, or is it okay to turn back and say or take permission of the judge? Ayushi, so there are certain rules in the Indian moods which provide for compendium. Certain rules prohibit it. So instead of thinking of compendium within that scenario, you have to look into this beforehand itself. If the compendiums are allowed, you have to make sure that the compendium is already there on the table of the judges. If the compendium is not allowed, this is not even something which you have to worry about. But this is very dubious because some of the judges will take it negatively that why are you looking back or why are you passing check to pass the compendium? Why didn't you do it beforehand? So I'll say the smartest thing is check the rules. If it provides for compendium, make sure that the compendium is right there on the table. Okay. Otherwise, let's say if you're ending up into this situation, it's very easy. Whenever you start the pleadings or something, you just ask for the permission from the judges. Very simple. Okay. Instead of looking back and then, making gestures that why don't you pass it? That's still better. Okay. Okay. Rupal is saying, as you said, that one should not overdo things like bombarding case laws in the oral arguments. So does the same thing applies on the moot memorial? Here's the thing, in the moot memorial, let's say if you are making an argument with respect to a very simple thing, what do you mean by an arbitration agreement? What do you mean by consent? When I say in memorials, you can use more set of cases, but that doesn't mean that you should use unrelated cases. So what Indian students also end up doing, for example, for consent, let's say you are talking about an arbitration agreement, you talk about consent. So what you do, you go to SEC online, you go to section 7, you get 100 cases and you put a footnote with 30 cases. This is something which I highly discourage. You have to use the cases which are related, which proves a point. So in the memorials, I'm not saying that you should have just one case or two cases for a whole issue. You can have more cases, that's not an issue. But you shouldn't overdo things in the memorial. For example, for arbitration agreement, definition, you have 10 cases, 15, 20 cases. But let's say the whole essence is with respect to non-signatory in arbitration for which you quote just one case. But all the other cases are super generic cases, which are more into like part 1 applicability, which are more into the definition of arbitration agreement. So I will say you can use more cases, of course, than the oral ones, but you shouldn't overdo things like for one particular simple thing, arbitration agreement, you put 20 cases in one footnote. And what does that add? But let's say I'll give you an example. Let's say it's a question on if the award has been set aside outside India, whether that can be enforced in India. Then you can refer to 5 jurisdictions like Singapore, France, different places and different cases to make an argument. This is what you are supposed to do in the memorial. Okay. Any other questions? Okay. Now let's talk about strategies to excel in moot competitions. Okay, this is a very difficult question to answer, but I'll try to answer from my perspective. One is that you need to have a good memo. A lot of us think that oral rounds is something based on which you go to the knockouts. Some of the moots also provide that memo marks is different, oral marks is different, especially in this your memo marks is unrelated to the oral rounds and the knockout rounds. But I'll tell you this, when you have a good memorial, it's more like the base, the building base. If you have a good base, it's very easy to build upon it. So one is that you have to have a good memo. How you had a good memo? Good memo is a memo where you have a good blend of mix of factual metrics and the legal research. If you have a good mixture of this, it's a good memo. One of the example which we just talked about is the case laws. If you are just dropping a lot of cases which are not even related, it's not a good memo. You have to make sure that the factual matrix has to be aligned and that is related, then it's a good blend. So memo is one. That memo has to be good because this is something which we are going to argue in the oral rounds. If you don't have a good memo, it's very difficult for you to overcome that in the oral rounds. In the oral rounds, in the preliminary rounds especially, there can be different standards. For example, like one of the team can be on a different pedestal, the other team will be on a different pedestal with respect to the legal knowledge. Okay. But understand this, when the teams reach the knockout stage, do you actually think it's a lot of difference with respect to the legal knowledge? Not really, because almost all the teams know the landmark judgments, the main provisions, main laws, and all of this. So, what's the difference? The difference lies in the oral advocacy, the presentation. So, For the preliminary rounds, maybe if you are very heavy with law, you will sail through it. But when you get into the knockout, almost everyone on the equal pedestal, and there the oral advocacy plays a vital role. So, how do you improve oral advocacy? Things which we just discussed: teamwork, coordination, time management. How do you have a good, attractive presentation? For example, when you start, you need to have a storyline about that particular set of facts. Storyline is more like 3, 4 sentences, which actually creates an image in the mind of the judges that you guys are the good guys. Okay. So all of this helps you to get more marks in oral rounds. So combination of memo plus orals, this is how you actually excel in moot competitions. Let's say that even after the rounds, you get certain feedback. So you should, if you get feedback, you are actually fortunate, because when I was doing moot competitions 13 to 18, not a lot of people used to give us feedback. So it was very difficult for us to know exactly where we land. But nowadays, we see a lot of good changes in India that we do get feedbacks. So it's better to write the feedbacks and things on which you have to work upon. And so this is more or less answering strategies to excel in moot competitions. The last part I want to talk about is handling competition pressure and stress. I know it's a bit stressful when you are a law student, you have your day-to-day curriculum, you have assignments, and then you sign up for something like this. Sometimes you have to also take care of the funding, visa, if you are going for international moots, bookings, all of this. It's very difficult. So it's like what we used to do is more like for making more like a timetable for this. So instead of meeting every day, what we used to do, weekly meetings with the team members. We used to divide work in between ourselves. Every week used to meet, and then we had accountability in a sense that every meet everyone has to update what things you are working upon. So this is something which we did. And if you have a timetable for, like, let's say first submission or first draft, then second draft, then you have a moot coach or moot mentor who helps you with this, who gives you comments for your memo or let's say your oral rounds. So this is actually something which is helpful, and now a lot of teams do that, especially for the international competitions. Because unless until you have a plan, it's going to be very difficult. Because what you will be ending up into is this, that let's say that submission is 25th of October, 23rd of October, you will start writing the memo. And then there is another team which has prepared this for the last 1 month. So it's, of course, the other team has spent more time, has done more research, so they are going to get more marks. Unless until you guys are super exceptional. You can do everything in like 24 hours. So this is how you actually handle it. It's more like managing your time and planning it. The more you plan, the more you manage, it's going to be easier for you. Otherwise, of course, it's very stressful. Okay. And the same applies to memo as well as your oral rounds. You need to fix your practice rounds. You need to do practice rounds with some seniors, with somebody who's actually doing that moot or who's good into that subject matter. Don't go to, let's say, for a constitutional law moot, practice round with an arbitration professor, unless until you want feedback on the oral advocacy, not for the subject matter expertise. So you have to make sure that some rounds you have rounds with experts on moot, some rounds the subject matter expert. Once you get the good balance of this, it's easy for you to make it to the knockouts. Now let's go to the questions part. Mahesh has asked, if opponent lawyer is giving false claim, can we stop them and provide our reference to claim it is a wrong claim? Okay, it was just the reply. Okay, Mahesh is asking, moot competition considers drafting also and its content for results. Yes, of course. So of course, like when there is a this the moot memorials, of course, this is something which you have to take into consideration, that how you have drafted, and there are separate criterion. One is more like your structure, like how do you structure this, how precise it is. The other one is more like your legal knowledge. Third is how do you use the provisions, the case laws, all of this. So if you check any of the moot competitions, you'll find this as one of the criteria. So of course, drafting and the contents are actually something on which you are going to be marked. And understand this, being factually wrong is one thing. Let's say that from the facts you misinterpret something. That is one thing. But let's say if you say that this is the Supreme Court binding judgment and that has been overruled, that's more like a misrepresentation. So you have to be mindful of, making big claims. Okay. So this is something which I wanted to share it with you guys. If you have a question, please feel free to ask questions because I think we still have some time left. Okay, so we have a question by Rupal. While addressing the facts, can the facts be extended as per the convenience, or it must be addressed as they are provided in the Moot proposition? If your question is, can you start adding to the facts or interpreting it in different manner? My answer is all the Moot problems, doesn't matter it's an Indian Moot or Jessup or Wes, all the Moots have one rule in common, which say that you have to interpret the fact as it is. You can't presume, you can't extend, you can't preempt. So you have to read the problems as it is. Why? Because let's say if you are the claimant, you will interpret in your favor, the respondent will interpret in their favor. Then you know what happens in a moot court. If there is a judge like me, you know what I will ask? I'll make sure that you guys start discussing this instead of your main arguments. So it's more like a trap. If you fall for this trap, you lose out points. So it's more like a short answer is this. Anything which you say, if that is something which leads to a question from your judge, you shouldn't do that. For example, extending facts. For example, using so many cases which are unrelated. What if I ask you what happened in that case? Who decided that case? What is the relevance for that case? What was the ratio decidendi in that case? Why is that case relevant? Which year it was decided? Which court it was? Anything which leads to question, which is not going to help you make your point, you shouldn't. As simple as that. Okay, the next question is Ayushi's question. According to you, how much minimum time is required to prepare everything for moot court? Also want to know how much time you require to do it. Okay, this is a very subjective question. How much time it is required to prepare everything for moot court? Because I did Wismoot thrice. So for Wismoot, the timeline is the problem is released on 5th of October, the first week. The moot happens in last March or early April. So it's more like a 9 months moot. I did this moot thrice. But there are some Indian moots which are notified like, let's say, 1 month in advance or 40 days or let's say 4 months also. So ideally, if you ask me, it depends on the timeline of the moot. Because if you are doing a national moot in India, which is from a XYZ law school, which says that in November the rounds are there, you have to prepare according to that. But if you ask me for the national moots, in my opinion, 30 days is a good time to prepare. But of course, for moots like FDI, Stetson, Jessup, WIS, it takes a lot of time. Why? Because their submission is also in two parts. So first in November or December first week, you have to submit one memo. Then in January, another memo. Then in March or April, you will have the oral rounds. Okay. For example, for Jessup, there is a national round. For FDI, there is a South Asian round. So it's a lot of process. But ideally, if you have 1 month or plus, it's a good time for you to prepare. But it's just that you have to plan and you have to make sure that there is accountability, that the work has been divided into different team members, you are having weekly meetings, then you have accountability. Otherwise, let's say if you say that we'll meet after 20 days, let's say the other person doesn't do anything, then how do you actually work on that? And then on the last day, your teammate says that I haven't done anything, so why don't you write it in the next 24 hours? So it's better to plan and finalize the timeline. Any other question?
If anyone have any other question, you can ask. We still have some time left.
Okay, so the next question is, do we have to state all the facts or the facts which are in our favor? Okay, guys, please understand this. Let's say that I'm arguing from the claimant, and I say things only which are in my favor. So let's say I have to argue on, let's say, arbitrability about certain IP dispute, that this is arbitrable. And I keep on saying that this is arbitrable. The Supreme Court of India, in this case, the Supreme Court of UK has said this, everything which is in my favor. This is scenario one. Let's say this is Saurabh. One side, he argues this. I'm against him. Okay, so he's arguing it's arbitrable. I have to argue it's non-arbitrable. What I argue is this: members of the tribunal, the issue here is that whether this dispute is arbitrable or not. As rightly pointed out by Saurabh, that one of the interpretation is that it's going to be arbitrable and there are certain jurisprudence for it. However, members of the tribunal, there exists another view which provides that it shouldn't be arbitrable. Now, in the next 15 minutes of my submission, I'll showcase why the interpretation that it is non-arbitrable is something which this tribunal should decide. So you see the difference. The first perspective is Saurabh says there is only one interpretation. I say that there are two interpretations. However, I'll showcase why you should choose the second interpretation over the first interpretation. Now, if I ask you which one is more attractive to you, which one is more balanced to you, of course, you will say the second one, right? Because in Saurabh is just showing one side of the coin. I'm showing both the sides. And then I say that this side is better because of these reasons. The same answer applies to your facts. Instead of if you don't say the facts, do you actually think the judges don't read the problems or the other person is not going to argue? So it's better to say everything which also goes against you and then you try to counter it in your arguments. Once you start doing it, you get bonus points for this. Okay. Okay, now let's go to the next question. Junita, any tips on how we can improve in legal advocacy skills, like how to sound more formal while answering back questions? I'll say it's a lot of things. One is your body language. So you will connect to this. When somebody asks you a lot of questions in the Moot competitions, you have a facial expression attached to it. For example, let's say you have a smiling face like this. Throughout the rounds, you are like this. Somebody asks you a question, and then you are like, you get the facial expression change, right? Body language is one. How you sit, how you talk is one. But the other important part is this. Somebody asks you a question, you shouldn't interrupt in the middle. So the rule is very simple. In your mind, you count 101, 102, 103. The reason why 101, it's 1 second. 102, 2 seconds, 3 seconds. So it's a 3 seconds rule. 3 seconds you wait because sometimes people have an habit of asking follow-up questions. For example, they ask you a question, they wait for something, they are thinking, and then they ask. And some of the judges will take it very negatively that you interrupted and blah, blah, blah. So it's better to follow this 3 seconds rule. How you give attractive answer is, of course, body language. Like you have to leave 1/3 of your chair from the back. You lean towards the table. You put your hands on the table. You don't have a facial expression. You don't change your facial expressions. You shouldn't be angry when somebody asks you a question. But the larger part of this is when somebody asks you a question, they want a very specific, direct answer. They don't want thank you for your question. Your question is very good. Thank you, your lordship, for the question. What you have to do is one sentence, one line of answer, because then answer, because, reasoning, one line. So it's just 2 lines. In the middle, you have to put because. This is how you actually answer the questions in a very attractive way. And this is how you get points for answering questions in the right manner. Vishwani has a question. Do we have to prepare differently for different moods, like arbitration mood strategy is different as compared with a constitutional mood? I'd say the advocacy part remains the same. It's just that the nomenclature is different. For example, you must have realized every time I say members of the tribunal, that is something which you use in arbitration. Instead of that, your lordship is something which you use in a constitutional mood. But everything else apart from this, the nomenclature remains the same. It's just that in the constitutional moods, you have to go to the dais. In the arbitration moods, you have to sit like this and then you have to argue. So everything which we discussed for the advocacy part or the memorial, it's the same. So not a lot of difference. It's just the nomenclature. Bhaskar has a question. Would you suggest to write the arguments advanced on memorial in the same format as we are going to present during the moot? Or would you suggest writing the memorial point-wise, the arguments along with sections of act and case law supporting the arguments at the end in separate paras? There is no written rule how you should write it. So in my view, it's very simple. For example, in this, what we used to do, so let's say there are 4 issues. So in the first part, let's say we write first issue. After that, we have an introduction paragraph where we lay down the storyline in the first part. Then we say that this whole issue is subdivided into 4 submissions, like A, B, C, D. Then we have A, and then we start with the factual matrix. Every time this is what you have to do. Because let's say if you have to interpret something, first you have to start with the facts, isn't it? Only when there is a lacuna in the facts, there is ambiguity in the facts, then you use the law, right? So how you do it? Write this now. There are 2-3 ways of doing this. One is IRAC, you must be knowing it, issue, research, analysis, conclusion. In the international moods, it's not IRAC which is most favored, it's called CREAC. It's called CREAC. C is the conclusion, R is the research, E is explanation, A is analysis, C is again conclusion. So there are good exercises on Google. If you write this, you'll get to understand how you should write. Okay, so instead of following what you have said, it's better to follow either something like IRAC or CREAC. Okay, so that is something which you have to understand, that one paragraph, one idea, one argument. That's the rule which you should look at. The next question is, sir, can we refer international case judgment to our courts? I think you can, if let's say it has an international flavor to it, even though it is not of a precedential value, but it will have a persuasive value. But when you argue this, you have to make sure that this is something which is having a persuasive value. We know that this is not binding. But you can. But it also depends on the subject matter. Let's say if it is very Indian subject matter, it's not going to help. But let's say if it's about arbitration, please feel free to. So it depends on the subject matter. The next question is, this is not a question, but you are certainly a good speaker. The session. Okay. Thank you very much, Tupul. Yes. Okay. Ayushi has a question. As Supreme Court is not bound by High Court judgments, I think we can still use to make our arguments strong. Yes, of course, guys, please understand this. Not everything has to be binding. Not everything which the Supreme Court decides is going to hold the ground. For example, Section 377 was a criminal offense. Somebody was arguing that it shouldn't be, quoting foreign judgments, but now it's not a criminal offense. The law has changed. So, of course, you are free to use arguments from there. Okay. But you have to be aware that you don't say that this is binding. You go to Supreme Court and you say that Jharkhand High Court has said this and this is binding. You can't be wrong with that. Okay, Anjani has a question. If you start for the very first time, what will be the first step to go for any competition? Very difficult question, but I'll say that first thing, if I would have been in your position, what I'll do is look into the subject matter, try to find out the winning memo of that. Then I try to find out the final videos. Then I'll try to talk to people who have done that moot from your law school or some other law school and get some insights how to prepare for that. Meanwhile, on internet, whatever relevant resources for that particular subject matter, I'll be finalizing all of this. That should be my first step, because until you know what is that moot about, what is the subject matter, what are the resources, and all of this can be done if you know somebody who has done that moot and they were good at it. So that's something which should be the first step. So it starts with internet, of course. Malika Arjun has a question. Sorry to ask again, there's a small doubt. Abbreviation must be 2 pages, or it should be strictly with memorial minimum pages. Okay, so this is very subjective. Some of the rules do not provide for any page limit. So whatever abbreviations you use, you just put it. Let's say if you have a lot of abbreviations, so you have to put it. Some of them provides for a rule that you can't go beyond 1 page or 2 page, whatever it is. So it's a very rule specific, and it doesn't actually affect a lot of your marks. It's just that you follow the rules. If they say you can put your abbreviations, how many, whatever numbers you have. So please read the rules for this, but not really, it's going to make a lot of difference. Yashveer is asking, in the changing of memorials, is it possible I get other memorial and my memorial will get any other? So should I effort to prepare memorial or prepare arguments? I'm really sorry, I'm not able to follow your question. What do you mean by this? Because I get it, like memorials are exchanged. If your question is whether you should follow their structure, I'll say not really. So the rule is fairly simple in moots. Let's say if I am claimant, Saurabh is respondent. I have this order ABC. So when I start with ABC, Saurabh cannot say that I prepared my arguments like BAC, because he's the responding speaker. So he has to write down my structure and he has to accordingly shift his pleadings into BAC instead of he has to do it ABC. He can't do BAC and say that, it's I have prepared differently. So you have to be smart when you are doing the responding parts. And for responding part, if you mirror the structure of the claimant, you get more marks. Okay. Anjali has a question. If you start for, okay, I answered this. Ayushi has a question: how to deal with the situation when we suddenly blank out? So usually what we used to do in WIS, at least the pre-moots, is very simple, that in arbitrations you have a table right in front of you. For example, I'm sitting and I have a table. So we used to get paper cups and water bottles, the glass ones. And every time somebody asked us a very tough question, so we had this thing that, you